SJC-11413, Somerville Retirement Board v. John Buonomo.
Thank you.
Good morning, and may
Oh, hold on, please.
Sorry, Your Honor.
That's okay. We want to put you on tape, and we can't do that until Mr. Keneally does his work over there. We all set? All right, let's proceed. Good
Good
morning.
morning, Your Honor. And may it please the Court, my name is Matthew Buckley. I'm an Assistant City Solicitor, and I'm here today representing the Somerville Retirement Board. The Somerville Retirement Board voted to forfeit the pension of one John Buonomo. Buonomo, at the time, had been convicted of various offenses. He had been elected Register of Probate, and he committed crimes stealing funds from copy machines and money vending machines that were of the Registry of Deeds, which was housed in the same building as the Registry of Probate. At the time, he had already been retired and was collecting a pension from the city of Somerville. His pension was contributed to by both the county and the state, but it was administered by the Somerville Retirement Board. When the Somerville Retirement Board realized he had a final conviction, they then gave him a proper notice and hearing and voted to forfeit Mr. Buonomo's pension. They forfeited under two of the statutes under Section 15, subsection 3 and subsection 4. Subsection 3 is basically states that if you're convicted of an offense involving the funds or property, and then it refers back to Section 1 of a governmental entity referred to in Section 1, subsection 1. Subsection 1 lists three different elements of what type of government entity. It lists the government entity by which he is employed. It lists the government entity by which he is employed at the time of his retirement, anticipating that he could have already been retired and went back to that government entity and committed an offense there, or any system of which he is a member.
And so you would say that would include the whole Commonwealth system?
Well, he was the Registry of Probate that he worked in was a part of the Commonwealth, and he certainly was using the property. He had a key to that building. He stole funds.
But was he a member of that system?
He was a member of the Somerville retirement system, and I would say to the court that the words used are any member. If you look at Section 3 of Section 32, it says there are two types of members, Your Honor, and there are both retired members, inactive members, and active members. At the time, Buonomo was an active employee, but he was an inactive member. He was a retired member collecting a pension at the same time as he was working and collecting his pay as Register of Probate. He was contributing to a system, but it was not a system controlled by Section 32. If you're an employee not contributing to the system of the Commonwealth, then you're not a Social Security employee. You have to submit through OBRA, and you have funds that go into a retirement fund of some type. But
So while he was at the Registry of Probate, he was contributing to a different retirement fund?
But he was not contributing to the, he had the option. It is a position that falls within the state retirement system. He could have, as an elected official, even though he had already retired, he could have opted to re-enter the system and begin contributing and gaining creditable service, but he chose not to. He chose to.
So he wasn't contributing to anything?
Well, he was. He was contributing to what they call OBRA, which is Omnibus Budget Reconciliation Act.
Is this sort of an alternative?
It's an alternative to Social Security, yes, Your Honor.
But what is the governmental unit? I understand he was the Register of Probate. What's the definition of governmental unit? I mean, is that considered?
Well, the governmental unit is described in definitions as it can be the Commonwealth or any political subdivision thereof. And in this particular case, he worked directly for the Commonwealth ever since the counties were all taken over by the Commonwealth back in, I believe, 1997. And But the thing I want to point out about Section 15.3 is that 15.3, referring back to 15.1, it says, if he's convicted of an offense involving the funds or property of a governmental entity by which he is employed. Now, it's significant, I think, that they also say in 15.1, which is, referred to in 15.3, if he's convicted of an offense involving the funds or property of any system of which he is a member, why would they say any system of which he is a member and also say, or by any governmental entity by which he is employed? I think they anticipate that you could be employed by a governmental entity and not be a member of that entity. And as has been cited, on various occasions, they talk about how 15.3 and 15.4, 15.3 is considered a restitutionary type of statute.
I want to ask that. According to 15.3, if he were to pay full restitution, he would be once again entitled to receive his pension, would he not?
He could be, although the Somerville Retirement Board would argue that 15.3 and 15.4 are, not mutually exclusive.
I understand that.
Exempted, but yes, I would agree that is what 15.3 says. However, Mr. Buonomo will tell you that it wasn't proper to use 15.3 because we didn't establish a sum certain that he stole. And the retirement board would argue that the sum certain is they're putting the cart before the horse. If he commits a qualifying offense, his pension gets forfeited. Only after his pension is forfeited should the court be interested in establishing a sum certain, because the sum certain isn't to establish his forfeiture, it's to establish his reinstatement, or whether he is allowed to obtain a return of his contributions. So that's where the sum certain would come in. And I would argue that if he's entitled to a return or entitled to reinstatement by making restitution, that the burden would be on him and not on the retirement board to establish a sum certain.
But 15.3 differs from 15.4 in that 15.3 says that you may also that he's not entitled to the return of his accumulated total deductions until he makes restitution.
Correct, Your Honor.
But I didn't see from your order that you were seeking to do that. Is it your position that if you prevail here, he will get back the amount of his deductions, or are you claiming?
Well, no, Your Honor. In this particular case, that's a moot issue because he's been paid, he was retired for over 10 years. He's been paid more than he contributed into the system already.
So that's not an issue before us.
No, it's not an issue.
There's no question here of accumulation.
There's no question of whether he's going to get restitution. He may use that statute to try to establish restitution in the future so he can get reinstated into the system, potentially, I suppose. But I would suggest that
if you're forfeitable under Section 4, payment of restitution would do you no good.
That's correct, Your Honor. I would agree with that.
Could I ask you about 4? Actually, both the district court and the Superior Court judge, am I correct, seem to say that, actually with respect to both of these, that the funds had to be of the funds at issue had to be of the retirement system by which he was getting paid, right?
It doesn't say that in Section 15.4.
Well, that's what I was going to ask you, but that is what the court's the judge
That is correct. They basically...
So what is the reason? I'm confused as to where that comes from.
Well, that's my argument is that it's made up out of whole cloth, Your Honor. The 15.4 has been considered to be a punitive statute. However, it has very distinct language in there that it specifically says, in no event shall any member. Basically, in no event means under no circumstances whatever. Shall any member, again, any member is under Section 3, both a retired inactive member and an active member, who is convicted of a law applicable to his office or position. It says nothing in there about an office or position to which you are, contributing. All it says is if you're convicted of an offense related, applicable to your office. the Superior Court did find it, and it can be found at A15, that it is undisputable. Judge Murtaugh found that Buonomo's convictions directly related to his position as Registrar of Probate.
Right.
And I would agree with Judge Murtaugh in that respect. And where we would differ is with respect to the addition of the element that he must have committed the offenses in an office or position to which he is gaining creditable service.
Can I go back to 15.3 on the restitution? If, to whom would restitution be made?
It would be made to the retirement system.
Well, to the retirement system, but not to the Commonwealth?
Well, yes, excuse me, that's correct. I was,
So,
that is
I mean-
correct. It would be made to the Commonwealth to the extent that he can establish the amount of funds he stole. I mean, part of the problem that the retirement board has is we can't determine how much he stole. It was circumstances such that he was caught midstream. They didn't get a specific dollar amount. They can estimate. I've seen two estimates written, one in the 30,000 range, one in the 80,000 range. That disparate. So it would be the position, as I said, of the retirement board that the burden would be on him to establish what the restitutionary amount is and establish that he's paid it.
But not to the Somerville retirement?
No, not to the Somerville Retirement Board. That's correct. That would be to pay back the restitution to the government entity from which it was stolen.
Was he an employee of the Commonwealth when serving on the Somerville Board of Aldermen?
He was, Your Honor. He had a full-time job.
Wasn't he county commissioner? Was he county?
He was county commissioner. Well, he was executive director of the for the county commissioners back in the day when they had a Middlesex, and then he worked for the state. I know he worked for the Division of Employment and Training when it was called that then, and he had an executive position there. And I'm not sure what other job he had that he resigned from prior to coming. He resigned from a job, went back to the Somerville Board of Aldermen, decided not to run for re-election, retired, was collecting his pension. Then later that same year in 2000, he ran for Register of Probate.
How is this situation any different than the case involving Mr. Bulger?
Well, it's different in the respect that Mr. Buonomo was on duty in his job when he stole the funds, for one thing. So I think he's more directly and less attenuated to the crime than Mr. Bulger was. Mr. Bulger was, his argument was that he was off duty in a different court, you know, and not at all involved in doing his particular job as a court clerk.
And was it so sort of a private issue?
Right. He was basically saying, I'm dealing with my own private business in which, you know, he committed a perjury offense. In this particular case, I don't think there's any question that, you know, if you're an elected official and you're entrusted with property and keys, and, you know, he's, I would say, much more directly related to his office than was Bulger. And
If you, this is not the greatest question, but if you were to prevail under four, well, you've got two I mean, they really are alternatives, or how do they work together in your view, 3 and 4?
well, 3 and 4 works together because, again, I believe it was Gaffney that said that those two are not mutually exclusive. You can have, if someone's retired,
Convicted.
Right. If he could make restitution, for example, under 15.4, he would be entitled to receive back his contribution, but with no interest.
Right.
So, you know, you would have to meld the two to say, well, how much is the restitution, and is there anything left over that you would get? So he wouldn't
and I take
necessarily
it
get
under
all of his return.
I take it under 4, he would get his contributions, no interest, but contributions regardless of whether he made restitution. Is that right?
That's right, if he didn't, you didn't also have 15-3.
Right, okay.
And again, with him in particular, it's moot, but, he wouldn't, there's no contribution to get back because he's been paid out all of his contribution.
Okay, from the state system.
Well, it's paid by, there's contribution by 3 different entities.
Right.
And it's paid out by the Somerville Retirement Board. And, but they get contribution annually. They make adjustments, and each system pays into the other system certain levels of contribution. So the Somerville system gets a contribution from both the state and the Middlesex County retirement system on behalf of Buonomo every year.
So in his case, if I understand you correctly, in his case, there is no difference. I mean, you don't meld them. I mean, in other words, if you prevailed under 4, 3 isn't going to help you at all, right?
Well, if we prevailed under 4, it would, his return wouldn't be an issue, so he would just have his pension forfeited. But that would be true of either 15-3 or 15-4 in reality.
Okay.
Except under 15-3, I suppose he could try to make restitution and get back into the system if it was just 15-3.
Okay.
Mr. Buckley, your time is up.
Thank you, Your Honor.
Good morning, Your Honors. Nicholas Poser for John Buonomo. All the facts that my brother has asserted to you, from the fact that Mr. Buonomo was retired to the fact that the Commonwealth and the County of Middlesex, or whatever is left of the County of Middlesex, is contributing to his pension, are not in the record. We don't know that as a legal matter, that anybody is paying a pension or contributing to paying a pension for Mr. Buonomo.
Well, we do know, don't we, from the record, that he worked for the state?
No,
We don't know that?
no.
Well,
Are you disputing
we
it?
do know that he was convicted.
I don't dispute that he was convicted. I don't dispute that he worked for the state as the Register of Probate.
No, I meant before that.
There's nothing in the record that supports the idea that Somerville is paying him a pension. Now, I'm not going to stay on my argument. I'm not going to sit down now, but there's nothing in the record. But moving along, the idea that when Mr. Buonomo was caught on camera furtively stealing coins from the copy machines in the Registry of Deeds, that he was stealing funds of the Commonwealth, and that therefore he is required to lose his pension under either 15-4 or 15-3 does not stand up to even cursory scrutiny.
So you're saying that the crime of embezzlement is not a conviction of a criminal offense involving violation of the laws applicable to his office?
Absolutely. However,
I'm sorry, absolutely it does or absolutely does not?
absolutely. However,
Absolutely what?
absolutely correct. Yes, that is in fact, if he had pension rights associated with his employment as the Register of Probate in the former county of Middlesex, yes. But in the record there is actually evidence that he was not a member of the state retirement system by virtue of his employment as Register of Probate.
All right, why? Why does it matter that the pension rights have to be from the entity that is employing him at the time that he commits the crime?
Okay. That's one of the two critical questions. And I would suggest to you that number one, section 15-4, which is what we're talking about right now, is narrowly construed. And it is implicit in 15-4 that there has to be a confluence of pension rights with the office that one is holding when one commits the crime that one is in fact found to be the violation of the laws applicable to his office or position.
What's the language that you are finding that implicit in?
Well, in the language of 15.4 per se, it says...
I'm looking at it.
Yes,
so-
and it doesn't say anything about for which you are holding pension rights. However, if you look at 15.1, and I think 15.1 is very important in this, and I actually have it highlighted right here. If you'll bear with me, I'll read it, at least the operative parts. Misappropriation of funds. Any member who has been charged with misappropriation of funds or property of any governmental unit in which or by which he is employed, present tense, presumably the registry of probate, or, I lost my place.
Any system of which he is a member.
Oh, any system of which he is a member. Well, he's not a member of the state retirement system. He was a retired...
When you say that, you're saying he doesn't contribute.
Well,
He did not contribute.
at the time of his conviction. Your Honor, more particularly, when Mr. Buonomo was retired by the city of Somerville from his position as an alderman in 2000, he was and continues to be a member of that system. The fact, again, and I say fact because there is no fact, but we will assume that the county and the Commonwealth are contributing under General Laws, Chapter 32, Section 3(8)(c) to the payment of his pension by the city of Somerville retirement system. He's not a member of those systems. He is by definition not a member of those systems because the funds have been transferred that were held by the county and the Commonwealth
So that
to
doesn't
the city of
depend on
Somerville.
the statute's definition of what a
Madam, I'm
member
sorry.
is. So you're not relying on the statute's definition of a member.
The statute definite. Well,
What is the definition, as you
well,
understand
the
member?
definition of a member. Well, there are two definitions: a member in service and member inactive. Member in service literally means someone who's working, is employed, or is on leave or something, but holds a job, and is a member of the retirement, and it has a connection to the retirement system. The second part, member inactive, which is he is a member inactive of the Somerville retirement system, but not of the Commonwealth and not of the whatever's left of Middlesex.
What does governmental unit mean? Do you have
There
to
is
seal?
there is a definition, Your Honor, I believe in General Laws, Chapter 32, Section 1. I didn't look at that this morning. I would suggest to you that it's probably a formal political subdivision. I think that would most likely be the definition.
So is the Registry of Deeds part of the same governmental unit as the probate court?
I don't think so. I believe that they're separate, and I don't mean to...
Does that matter?
I don't think so. And let me just, I have one other thing to say to you, if you let me say it, is that when he was caught taking money from the copy machines, it is my view, and two judges have agreed, that's why you're here, is that that money was not Commonwealth funds, or at least not Commonwealth funds yet. If you see in the record, there is a contract between the RICO company and the Commonwealth. And in essence, it says that RICO
41%, right?
45% of the funds, once they're collected and counted. Now, clearly, he interrupted that flow. He diminished, I will concede, he diminished the amount of funds that the Commonwealth would have gotten. We don't know how much money that is. I think that's significant for another purpose under 15.3. But
Isn't
we were
that a
talking-
larceny of a reasonable expectation of a property interest?
ooh, I don't know. I'm so far from law school, I'm not sure how to answer that.
Well, so that it wasn't anybody's property, according to you. It wasn't even RICO's property.
I believe that I say in my brief that it was RICO's money. He stole from RICO, not from the Commonwealth, because the Commonwealth, the money in the bins, the money that was that was held in the copy machines and the money changers was RICO's until it paid the Commonwealth. And that's important for several reasons. Number one, it's not a theft of the Commonwealth. Number two, and what I've been leading up to is the idea that he didn't, that even if he stole, even if you find that he stole from the Commonwealth, because at least my reading of 15.1.
Could you get back to my question?
Please, sir.
Does it make any difference that, if I understand your answer correctly, does it make any difference that the probate and family court is a different governmental unit than the Registry of Deeds?
I think so, because the 15.1, again, going back to 15.1, it's all we have is to what the jurisdiction or what the coverage of these particular forfeiture law is. It talks about the unit in which he was employed or was retired from. Well, I think it's clear that he didn't steal from Somerville, and there's just nothing to do with Somerville. He didn't steal from the Registry of Probate. Just as an aside, there's no facts in evidence that you can take cognition of per the Scully case, because there's no plea colloquy, that he actually used a key that he was given as the Register of Probate to access the identical kind of copy machines in the Registry of Deeds. It's just not in evidence.
Is the registry, or is the Probate and Family Court, or is the retirement system for the employees of the Probate and Family Court the same retirement system that applies to the rights of the employees of the Register of Deeds?
Well,
and does that matter?
Well, answer your first question first. They're both covered by Chapter 32, Chapter 32 of the Retirement Law of Massachusetts for public employees. They're both of those entities would be employees would be members of the state retirement system. So in that respect, yes, but they are different political subdivisions, I believe, if that is the proper way to analyze that, and therefore they're paid differently. They're different arms of the court system. I don't think it's particularly important to the analysis because, again, I don't think that the money was stolen was Commonwealth funds, and even if it was Commonwealth funds, which I don't think it was, it's still, there's no proof that that any part of his pension was being contributed to by the Commonwealth. That's number one. And number two, and more importantly, in 15.1, there's nothing in there that says, I don't think, that an entity that contributes to the payment of the pension as opposed to an entity that was employing someone who had pension rights is a trigger for a misappropriation of funds forfeiture under Section 15.3.
Under 15.1, what does the phrase "or any system of which he is a member" mean? Does that mean that you have to steal from the retirement system?
No, I think it means that you were. I think it relates back to the employment. So, and again, he's not a member of the state retirement system as a register of probate. That's very clear. He had no pension rights. I think that it means that it is there to cover the situation when someone is not employed, meaning is a member inactive, but sort of is in between employment and retirement. Which is,
if he had stolen money from the town of Somerville after he retired, went back in and took money out of a cash box at the tax collector's office, would his pension be forfeitable in your view?
not under 15.4, because it's post-retirement.
Okay,
I
but
think
what
there's a
about
bright line.
15.3?
And I'm thinking hard about that. Probably, although there's a savings in 15.3, it's very clear that if you steal from your employer, or in this, or someone who's paying your pension post, even post-retirement, that you can pay back, you can make restitution. And I think the sum certain is important. I disagree with my brother graciously on the analysis of who's got the burden of proof. It's my view, and there's a couple of, there's not a lot of cases on this. There are basically 3 cases. I only cited one, the Doherty case, because that was sort of the most interesting, compelling. There's the Arruda case, which I believe is a 15.1 case also, but there's also the Cohen case, which is actually in the record, and I cited at page 60. Chief of Police in Malden was charged with getting, under the exam scam, getting a salary that he wasn't entitled to because he cheated on his promotional exam. The sum certain has to be established before the pension is forfeited, because it's, again, implicit, but it's really clear, and 2 judges have agreed with me, that the pension forfeiture amount is necessary because the employee has the absolute right, per the statute, to make restitution and pay it back and stay in the system.
Okay.
So the sum certain has to be established by the retirement system. That was certainly established by the Medford Retirement Board in the Doherty case, and certainly by the Malden Retirement Board in the Cohen case. And I think that that's a natural reading of the statute.
Could I, way back when we started, you were talking about 4. And,
Yes.
and then you skipped over to subsection 1, and I don't understand why we need to look at 1 to interpret 4.
Oh, well, it's my reading of 1. If you look at 2, which is not cited, but it's in my materials at page, looks like I,
Yeah?
which is, I cite all the statutes, section 15, 1, 2, 3, and 4.
Okay.
And 2 says, initiation of proceedings. Proceedings under this section, and I think may be initiated by blah, 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 blah. Proceedings under this section meaning 15. So these 4, and there's more now, but these 4 sections all are governed by the same definition section in section 1, and they're all related. So the description of a member, the description of who's paying or who's employed by, I think they all are read together. Again, this didn't come up in briefing, but I think that they're all connected, and I think that you read 15.1 to establish where the jurisdiction.
Section 3 makes an explicit reference to 1, and
Yes.
Section 4 does not.
Yes.
That has some significance, doesn't it?
No, because 15.2 takes care of that. The legislature's told us that 15.1, 2, 3, and 4 were read together. It doesn't make any sense that they wouldn't be. Well, just by taking a look at 15.4, what is the title of 15.4? Forfeiture upon misconduct. Forfeiture of what? Forfeiture of the pension benefits that you have earned while being employed by your employer.
Mr. Poser, your time is up. You're going to have to summarize for us and wrap it up.
Thank you, Your Honor. Neither 15.3 nor 15.4 apply to Mr. Buonomo's crimes that he committed while register of probate. Thank you.
Thank you.